Good afternoon and welcome to Pay Entry's weekly webinar. Today we'll be presenting information on the new Cobra subsidy that's in place as a result of the American Rescue Plan Act, which was effective April the 1st of this year. My name is Kathy Graham and I'll be the presenter today. I'm joined in the background by Brianna Grimes, who is the Senior HR Consultant for Pay Entry, and we want to welcome you to today's session. First of all, just to let you know, we're not attorneys, and so when we conduct these webinars, we are doing it to provide information, and we're not giving legal advice, just to let you know. Okay, so you offer health insurance. These new Cobra subsidy laws do apply to you. I'm going to give you a little bit of background on Cobra first. Cobra is a federal law that obligates employers to offer group health plans when someone loses their coverage based on a qualifying event. And there are about 5 different types of qualifying events. Today, this coverage focuses on only one of those. The language too in Cobra refers to qualified beneficiaries. And a qualified beneficiary is an employee or a dependent of an employee who is actually on your health plan and loses their coverage due to that qualifying event. So remember, people who are not on your health plan don't have any Cobra rights. They have to be enrolled at the time the event happens in order for that to be effective for them. If you are an employer that has 20 or more employees in the previous calendar year, you are required to offer Cobra laws or Cobra under federal law. This includes all your group health plans, and a group health plan includes medical, prescription drug, dental, FSAs, HRAs, and vision plans. You don't have to include life insurance or disability. Those are not considered to be group health plans, but I'm sure some of you might be surprised to see that FSAs and HRAs are group health plans and do fall under the Cobra laws. Those companies who have fewer than 20 employees may be bound by many Cobra laws that are designed by the states to apply to employers that don't fall under the federal laws. I know North Carolina and South Carolina have Cobra laws. I'm not sure of the other states just off the top of my head, but if you are interested in knowing if you are supposed to be following many Cobra laws, please reach out to either Brianna or me after this and we'll let you know. We can look that up for you. But I would say that the majority of the states do have many Cobra laws. So the coverage that's available under the state Cobra laws may be different. And you do not, there's no requirement under these new laws for you to change what you offer under Cobra. For example, in North Carolina, you do not have to offer anything other than the group health plan. You don't have to offer any of the other group health plans that I mentioned. So it does vary by state, and you do need to look at your state to determine what you should be offering. Also, the timeframes may be different. So there's a lot of different nuances about these state laws, and it would pay you to look into those if you have fewer than 20 employees. Let's look at the Cobra subsidy provisions of the Act. It is effective April the 1st of 2021. And unlike some other programs, this program is mandatory. You do not have an option whether you participate or not. If you're covered by Cobra or state Cobra, you have to participate. It does provide up to 6 months of subsidized Cobra premiums between April the 1st and September the 30th of this year, along with special election rights for those qualified beneficiaries. And it imposes 2 new notice requirements. As if there weren't enough in Cobra now, there are 2 new notice requirements that you have to follow. And it provides tax credits for your company or entity when they pay the Cobra premium subsidy. Now, let me just back up and tell you what this means. It means that between April and September, you cannot take any money from a Cobra participant. You have to pay the insurance company in full, and you have to recover that through a tax credit. So anyone that's paying you now would stop paying you from now until September the 1st, back to April the 1st, and then would start back up October the 1st unless there's some sort of an extension of this. Right now, that does not look obvious, but you never know in today's world. And the 2 new notice requirements on employers, we'll talk about that, but I have attached handouts today to this presentation. In your handouts section, all of the new notices are there, along with a copy of today's presentation. As I mentioned, under this new rule, you have to provide free Cobra coverage from April the 1st to September the 30th of 2021. And there are additional enrollment rights available to those who are called assistance eligible individuals, AEIs. These are qualified beneficiaries, and remember, that's anyone who has the right to elect Cobra under your plan. If they were already enrolled in Cobra and would continue to be enrolled during the 6-month window, you have to stop taking payments from them. Anyone who did not enroll in coverage when it was offered, but they're still in what would have been their 18 months of coverage under Cobra, you have to offer them Cobra again. And those who were enrolled in Cobra, but they let the coverage lapse for some reason, maybe they couldn't afford it, if they're still in that 18-month coverage period. So you're going to have to do a look back to determine who these people are. If they didn't elect, they're still eligible to elect now. And it would not go back to the first day that they were able to elect. It would start on April the 1st. They are eligible to enroll in what they had at the time, or a benefit. If there's a health plan that costs less, they could enroll in that, but they cannot buy up on their coverage. So of the things that you offer them, medical, dental, vision, and these other plans, the only change they can make is to go to a lower cost plan. I know that's going to cause a little bit of confusion for FSA, but if you have any questions about that, you can certainly reach out to me and I'll be able to help you with that. So remember, AEIs have special treatment. They can enroll if they didn't enroll before, as long as they're still in that what would have been their 18 months of coverage. It doesn't extend their ability to go past the 18 months. If they were eligible for this on January the 1st, and it would take them out 18 months, which would be what, July 1st of next year, June 30th, their coverage would end. They can only take coverage now until June 30th of next year. They cannot extend it any longer than that. And they lose this ability to have this coverage if they're no longer eligible. I'm sorry, if they become covered under another group health plan or Medicare. And remember, I said group health plan. If they had enrolled in individual coverage on the marketplace, they're allowed to drop that and enroll in your plan for 6 months. The 2 new notice requirements for employers include a general notice that has to be provided to anyone who's impacted by this, which includes an election notice and describes their rights to the subsidy for 6 months. There's also a notice that you have to send when the subsidy is about to expire, and you send that out 15 to 45 days prior to the expiration of the subsidy. As I mentioned, model notices have been published by the Department of Labor, and I have included them as handouts today. So you're welcome to access those. If you have difficulty doing that, reach out to us and we'll send them to you. There's also another form I want to mention that someone brought up this week. There's another form online that is for the employee. If they're not offered coverage by you, there's a form online that they can complete and send to you to request coverage. You should not use that as the election notice. So how do you get your money back? You are reimbursed through tax credits against your Medicare tax liability, and it all ends up going on your quarterly returns, your 941. The credit is refundable if the subsidy that you pay exceeds your Medicare tax liability. You will receive a credit from or a check from IRS, and that's done through Form 7200. So that would be an excess amount that would be returned to you. So you're going to pay this, but you're going to get it back in full. So what should employers do now? Okay, if you outsource your Cobra, then you need to call your third-party administrator, whoever's handling your Cobra for you, even if it's your insurance company. And a lot of group health plans do handle Cobra for you. Contact them and make sure they are handling the process. I always say if someone else is administering Cobra for you, it does not relieve the employer of the responsibility to be compliant. So always make sure that your vendor is doing the right thing. You need to make sure that they're using the right notices, that they're doing it within the correct time frame, and that applies to Cobra in general. There are a lot of third-party administrators out there that don't do it right and have gotten in trouble for it. And you don't want to be in a group that's in trouble. If, however, you administer Cobra internally, and a lot of small companies do that, talk to your broker about helping. Then download these model notices from the Department of Labor's website or use the ones I've given you. Go back and identify all the people that would still be in their 18 months of coverage if they had elected, and the ones that did elect, and then send out the notices. Make sure you keep a proof of mailing, because if someone says, I didn't get that notice, that's the first step in getting you in trouble. So make sure you do that. You do not want someone complaining to the Department of Labor that they didn't get this notice, because there are penalties involved. We will help you set up recovery of tax credits and pay entry. We have it will go directly in when you're entering your payroll. And there is a pay entry code that you will use to record those expenses. And it is ARPA Cobra. When you're keying your payroll, if you put the expense of that person's medical plan, whatever else you're paying for them, put that in there as the cost, and you will get a tax credit automatically through our system. I know that's a lot of information in a short amount of time. We like to keep these things short so we have time for questions. And Brianna is going to look at the question box, and she's going to help answer some of those questions today.
Hi, Kathy. Thank you so much for that great information. You were very, very thorough. We do have a couple of questions. Some of them seem to be some clarification questions. But before we get into the questions, we did have a couple people say that they were having some trouble downloading the Word documents. So if you were one of those people that are not able to download the Word document, can you just submit into the question box the words Word document, and we will send those to you at the end of the presentation when this is over. So we'll make sure that that gets to you. All right, let's jump into the questions. So we have a clarifying question. They want to know, so does this mean that the employer pays the premiums on the employee's behalf?
That is correct. You would pay the insurance company for any coverage that the employee had selected.
Okay. All right. How do you key the expense of that person's medical plan in payroll if they are terminated and no longer on payroll?
You know, that is a very good question, and it's probably going to require an amendment to the 941. I will get back with you on that question after asking our tax department. So make a note of that, and we'll follow up with you. But that's a very good question. If they already have terminated, there is no payroll for that person, and we'll probably do it by a memo code.
Okay, perfect. We'll make sure that we reach out to this client with that question. What if an employee was hired back? So they terminated and then they were rehired at the company.
If they're no longer on Cobra on April the 1st, you do not have to concern yourself with them.
So this is only from that designated period of April 1st to what is September 30th, correct?
That's correct.
Will they see the tax credits on the payroll summary report like how other Arpa works?
Yes, you will.
Okay. Right. What if they never had health insurance with the company?
Then they would not be a qualified beneficiary, and they're not entitled to elect Cobra. So they're not involved in this program, so they're not eligible.
Okay. Do we need to use the Arpa Cobra code in payroll if we are using a TPA?
Yes, you do. In order for you to get your tax credit, you have to go through your tax returns. So yes, you would have to do it in payroll.
And another question, are all previously termed employees eligible for this, or only if they were termed before a certain date?
You would need to go back and see if the person would be in an 18-month window of coverage had they elected. I need to calculate out what date that would be back from April the 1st, but if you had someone that was on the health plan and lost coverage due to, and it is a reduction in hours or layoff, if they quit, they're not eligible. I forgot to mention that, but if they did resign from your employment, they are not eligible. It's only if there was an involuntary termination, like a layoff or a reduction in hours, that put them in a situation where they weren't eligible for the plan anymore.
Gotcha. Okay. So if the employee covered their entire family, then the company would pay for the entire family.
That's correct. That is correct.
And then if this client only employs 8 people, do they have to follow these new rules? What was the eligibility for that?
The new rules these are federal laws, but the state Cobra, you need to check with your state or check with us. We'll find out if your state has a mini Cobra law. If you have fewer than 20 employees, you will be bound by any state Cobra laws that exist. And yes, you would need to participate in this plan if your state has a Cobra law.
Okay. Now, if a child ages off a parent's group plan, are they eligible for the Cobra subsidy?
No. And that's a good point, and I meant to put that in my slides, and I guess I forgot about that. The only reason, like if they age out or if they get a divorce or anything like that, that triggers a 36-month Cobra election time frame. This is only if someone was laid off or they lost their coverage because their hours were reduced. So layoff or reduction in force or reduction in hours.
And another clarifying question, this is just for medical, dental, and vision, not things like short-term disability, correct?
That is correct. No disability, no life insurance.
Okay. What if an employee was offered to be hired back but declined to come back to work?
It doesn't matter. If you laid them off, they still are entitled to Cobra. And if they don't want to come back, there's no law that says that they have to come back. And that would not be a reason for you to exclude them from this program.
Gotcha. And the subsidy includes the company paying the entire cost, not just the part that the company already pays. Is that correct? So they would cover the employee's cost as well?
Yes, the entire cost of the premium.
Okay.
For whatever coverage that person had elected.
Okay. Should we automatically start charging the employee the Cobra premiums after September, or is there like a notice or something that they need to send out?
Well, that you need to send out that notice between 15 and 45 days before September the 30th to let them know that the subsidy is expiring and that they would need to continue their Cobra payments starting October 1st.
Okay, and then they can start collecting those payments as of
Yes.
October 1st if they've sent that notice.
Yes, they can.
Okay. If a person goes out on a medical leave, are they eligible for the Cobra subsidy?
If they are on Cobra, no, medical leave of absence is not listed as one of the reasons that they would be able to elect this subsidy, so no.
Okay.
It's only from if they lost their job due to involuntary termination.
Got it. And someone's clarifying what the look back period is. That's 18 months from April the 1st. Is that correct?
Well, it's not, the look back is not 18 months. You have to look at these people to see if they would still be in, let's say they elected Cobra, they would be in their 18 months. And I have not sat down and calculated that, but I will. But you have to look at somebody who would still be in their 18 months effective April the 1st of this year.
Gotcha. Do you have a WebPay help article that notes how Cobra should affect tax forms?
I'm not sure how to answer that question because no, we don't have one of those pages. Our tax department usually handles all the tax side of this, but yeah, I know that it will be an adjustment that we make to your 941s, your quarterly tax filings. But this is something that based on the code, we will do for you.
Gotcha. Okay. This one is a broad question. What would classify under reduction in hours?
If somebody loses their benefits because they don't work enough hours anymore, and that's the reason. But it would be reduction in hours that causes a loss of benefits. So if they weren't on your plan, you don't have to worry about them. If they were on your plan and let's just say you took them from full-time to part-time and now they don't qualify for your benefits anymore, then they would be included in this. And I just thought about that look back period too. I mean, if you look back 17 months from April the 1st, somebody would still have 1 month of Cobra left. So you would still have to offer that. It's almost, you do have to look back 18 months, but someone who elected that's in their last month may not care about this, but you would still have to offer that to them.
Gotcha. Okay.
If it gave them a 1 month benefit, then that's still something that needs to be offered.
Gotcha. So, as far as clarification goes, what if a employer dismissed the employee, like they were terminated, but it wasn't necessarily for a layoff or reduction in force? Let's say it was a behavior or an attendance. Would they still be eligible because it was not a resignation?
Yes, because you still would have had to offer them Cobra. If they had coverage and you fired them for something like attendance, they would still be entitled to Cobra. The only time they're not entitled to Cobra is for gross misconduct. Be very careful of denying someone Cobra under gross misconduct ruling because there is no definition in Cobra of that. We usually fall back and look at what the state unemployment department would consider gross misconduct. And I used to teach a class on Cobra, and I'd say if they come in and they shoot the boss, that is gross misconduct, and you can refuse to give them Cobra. But if they fail a drug test or they just don't come to work on time or regularly, that is not gross misconduct. So it has to rise to the nature of being egregious and something that would be just, I mean, if they are selling drugs on your property or they get in a fight and hurt somebody at work, yeah, that's gross misconduct. But be very careful how you use that.
Okay. And what if they did not make it to the 90-day waiting period in order to become eligible for benefits, and they would not be
Again,
offered
if they're not eligible for benefits, if they never enroll in your benefits, they're not entitled to this.
Gotcha.
They have to be someone that was on your plan that lost coverage because their employment was terminated or their hours were reduced.
Okay. Are we going to add the Arpa Cobra code for all clients? So I guess the question is, are all clients going to have that code available to
Yes.
them in the system?
Yes, they will. It has been loaded already.
Okay, perfect. And how many hours, days, or months do they have to work in order to qualify for Cobra?
Well, that's up to you. The way that they qualify for Cobra is they're on your health plan. If they're on your health plan and they lose it for the reasons that I mentioned, then they're entitled to Cobra. If they leave because they resigned, they're still entitled to Cobra, but they're not entitled to this subsidy. So anybody who loses coverage for almost any reason is entitled to Cobra. The subsidy is different. It's only those who were terminated in the last 18 months, basically, and who were on your health plan or your dental plan or your vision plan or your FSA and HRA plans. Because remember, those plans count also.
Gotcha. Now, if a company, when the employee was enrolled in the benefits, they enrolled for just themselves, so that they never paid for the family while they were employed.
Hmm.
Would the employer then need to pay for the employee's family members if they enrolled in Cobra for their family?
They can't do that. They can only enroll for the people who are considered qualified beneficiaries at the time they lost their coverage originally. So if they were the only one on the plan, they cannot add family members at this time.
Okay,
They can
so
only add, they can only, Cobra is only offered to those who lose their coverage. And if the family wasn't enrolled, they didn't lose it.
okay, so it should be apples to apples for in
Apples to
terms of
apples.
what coverage they had
Hmm.
during and then post employment.
Right. Hmm.
Now, when you say elected Cobra, do you mean that they actually were enrolled up to 18 months prior to April 1st? So did they have to enroll prior to April 1st for this to be considered?
No. Remember, back on one of the slides, I mentioned that if they didn't enroll, they're still eligible for this. You have to go back and offer it to them now. Now they may
As
be
long as they're
enrolled
in
on,
that period.
yeah, as long as they're in the prior 18 months prior to April the 1st. If they left during that time frame, then and they were on your health plan, um, then you need to offer them this coverage if they were enrolled in your health plan.
Okay. And what is the date that the first notices for employees needs to be sent out by?
Well, they don't have a date, but you should do it as quickly as possible because the benefit was effective April the 1st. That means that you're going to need to return funds to those who have paid you. You have to give them their money back. And you don't want to wait too long before you get into this, and it does only last 6 months. So I would say as soon as administratively possible.
Okay. And just another clarification question. They want to clarify that medical leave would not be viewed as a reduction in hours, correct?
No.
Okay.
Well, let me ask this question. Did the person lose their benefits because they're on a medical leave? If they did, then it could be considered a reduction of hours, not a termination or a layoff, but it could be considered a reduction of hours. And if you want to call and we could talk through that, or Brianna, get the name of that person and I'll follow up.
Okay, absolutely. Where are the ARPA codes listed in the pay entry system?
The ARPA codes are, you mean in the payroll system itself? It is under the code section. The list of codes that you're able to use when you're keying your payroll. There's a new one that's been added, and the ARPA codes are there. They're also there for the leaves, the paid leaves that are authorized now. If you're using that program, which is voluntary, those ARPA paid leave credit codes are there also. So it's under your code section in your payroll screen. And
Gotcha.
if I'm confusing you to death on where the codes are, contact your client advocate, your customer service person, and they'll show you where they are.
Okay. What if a person decides to go part-time voluntarily and therefore there is a reduction of hours? Are they eligible for the Cobra subsidy?
They are not because it's voluntary.
If they enroll now, do we have to pay back the premiums for Cobra or coverage starting for one?
4/1, yes, you do. If they enroll now, you have to give them their, and they've paid for April, you have to give it back to them.
Okay. This is the long one. All right. The company paid benefits are only for employees and not for family. The company offers family, but does not pay the family premiums that the employee would pay. So the employee pays for the family, but the company pays for the employee. If they want their family to continue, does the company now have to pay for the family portion if they elect for the family in Cobra?
Yes, you do. You have to pay for the coverage that the employee has elected and return and get a tax credit for that.
And then another clarification question. So even if they did not enroll within the 60 days after termination for Cobra, the employers still have to offer this Cobra subsidy to employees.
That is correct. You have to go back for anyone who didn't elect, or someone that elected and dropped it. You have to go back and offer it to them.
Gotcha. What if the employee enrolls now but did not as of April 1st? Does the company have to pay back to April to the insurance company when there was not coverage?
If they're talking about a new enrollee in Cobra, if I'm a little confused about that. So if the person was on Cobra in April, you need to give them their money back. If they enrolled now, as of May the 13th, and they weren't on Cobra in April, then no, you don't have to. It's only if they are in a period of time where they're paying for Cobra.
Gotcha. So if they enroll now, essentially they just don't have to pay for it. They get the benefits, the employee does not have to pay, and the employer does in the form of the subsidy, correct?
And it depends. If this is a current employee and they just lost coverage and it would stop today, then they would start the subsidy program today. But if this person was one of those that you notified, their effective date would need to be 4/1, and you would pay for it retroactively to April 1st.
Gotcha. Okay, it looks like that is, oh, we have one other question. Can they only enroll for the subsidy period and then drop it?
Yes, they can.
Okay.
And they probably will, because if they wanted it before, they would have picked it up and paid for it. So yeah, you'll have a lot of people that come on for the 6 months and then drop off.
All right,
And
well,
that is allowed. Okay, good. Brianna,
that
thank
is
you
all
very
the questions.
much.
No
Great
problem.
questions, guys. I appreciate all of those. And we will have a recording of this presentation up on our website. If you want to go to the payentry.com website, you can view all of our past recordings. This one, it does include the Q&A, so you can listen to these questions and answers again if you'd like, along with the presentation. We want to thank you for attending today and look forward to seeing you next week. We have 2 webinars next week. We have one on Tuesday on voluntary benefit trends in 2021, and then we have one on Thursday. Brianna, it's an overview of our new APHR class, right?
I was on mute. Yes, ma'am, that is correct. We're going to be talking about the APHR class that we are going to be teaching for any of those out there that would like to get their APHR certification. We'll talk about what it is, why you should get certified, what the time commitment is. We'll give you all that good information.
Okay, well, we'll see you next week. Thanks for attending.